All right, at this time I want to welcome Bob Neiman, who will introduce our keynote speaker, Professor Jesse Chopa. Bob?
Thanks, Steve. It is a pleasure to introduce Jesse Chopa. For those of you who were here 2 years ago, and for those of us who have read his texts, and those of us who went to Bolt, he really needs little introduction, but I'm going to give a very brief one. First, Jesse asked me to let everyone know that he's going to talk for roughly 40 to 45 minutes, and then he's going to leave some time for questions. And I know a lot of you are going to have some questions, so start formulating them now. Jesse clerked after law school for Chief Justice Earl Warren on the U.S. Supreme Court. He then taught law in the East and the Midwest before coming to Cal in the mid-1960s. Where he has been a faculty member ever since. He had served as Dean of the Law School between 82 and 92. He is also an extraordinarily loyal and knowledgeable Cal football and basketball fan. So he's particularly excited about Cal's big win over Syracuse last night and their domination of Stanford tomorrow. He, as you know, he is the author of 3 widely circulated texts, including 2 that I bet most of us have studied from, having to do with corporations and constitutional law. He is a renowned speaker. He has been a guest lecturer and a visiting faculty member at numerous countries around the world, many in Europe. So he's going to give some of the lecture today in Swedish, Spanish, and Portuguese, and then he's going to shift to Australian, which none of us will understand. He has received the highest honors that Bolt Hall can confer for distinguished teaching, and he has also received those honors from the University of California, Berkeley as a whole. He is an extraordinary teacher. I think he's the best teacher I ever had the privilege of learning from in my entire life. And I'm so delighted to have the opportunity to present today my friend, Jesse Chopa.
Thanks for that very nice introduction. I was here several years ago, and I'm very happy to have been invited and to return again. The title that I give this talk, which is a review of the Supreme Court's last term, the last term really that has to this date, done anything, and it's called The Continuing Dominance of Justice Kennedy and an Emerging Special Role for Chief Justice Roberts. Okay, so I'd like to do 3 things before I start. I want to briefly outline the statistics of the last term of this court. It's a sharply divided court. It's basically 5 conservative-leaning justices and 4 liberal-leaning justices. It's been that way for over 45 years with a minor glitch about 30 years ago, but it's since the end of the Warren Court. Second, I'd like to discuss, about 5 or so of the most significant cases of the term, depending on the way the time goes. And third, as Bob mentioned, I'll take any criticisms or comments or even questions you get occasionally. Okay, so we go to the stats. Out of a total of about 67 cases that they decided on the merits, and you want to know that is from over 8,000 petitions for review. The 2/3 of those cases, this is, as I said, it's a sharply divided court. Yet 2/3 of the 67 were unanimous. That's the highest in 60 years that they've had unanimity like that. I count of those cases 26 constitutional decisions, including 4 that are really statutory but with important constitutional implications, and I'm going to start with one in a moment or two. There are about 26 of these that lend themselves to being characterized as reaching a conservative or liberal result, at least according to the way the 4 liberals and the 5 conservative leading justices vote. So a quick word of definition. You know, when you use the words liberal and conservative most any place, they've got to be somewhat oversimplified. But mine, I think, and this is for judicial review for constitutional decisions. I would say that there are 3 points that I want to make. How do you distinguish a liberal Supreme Court judge from a conservative Supreme Court justice in constitutional decision-making? The liberals tend to favor individual rights versus government regulations. Tend to favor. Nothing is totally black and white, okay? They tend to favor that, at least those kinds of rights that are non-economic rights and that usually protect minority groups, okay? Indeed, on that last category of individual rights case, which involve either economic rights or tend to favor much larger groups rather than minorities, there is a conservative liberal flip-flop on this court. The liberals favor government decision, government regulation. The liberals, the conservatives favor individual rights. The liberals favor government regulation. Right? Well, that's the first. The second is, which is easier to understand. Liberals tend to favor national power. Conservatives are advocates of states' rights. And the third, or as at least a corollary of the second, the liberals tend to favor an expansive role for the federal courts, and the conservatives tend to favor a more limited role, leaving many more decision-making matters to the state judiciaries. And the least clear, but nonetheless an emerging truth generally, is the conservatives on clashes between executive power, the power of the president and the Congress. Some of you may think we even have something like that today. The liberals tend to favor the exercise the conservatives tend to favor, as a rule, executive power, interestingly enough, whereas the liberals tend to favor congressional power. All of these are tens, and that's generally true, it's particularly true in time of war, but more generally as well. One thing is clear about this court. Neither side, neither the conservatives nor the liberals adhere to judicial restraint. And both sides, and I think this comes as no surprise to those who look at it at all, both sides are highly ideological. Okay, let's take a look at how the cases came down. Of the 26 constitutional or constitutional-like decisions, let's exclude 12, which are unanimous. It's 12 to 26. I do this slowly especially when I talk to groups of lawyers. It leaves only 14 after that. And on that account, the conservatives prevailed, but only by a 7-5 vote, which is fairly good for a liberal minority. When you don't have the votes. Now, on the remaining cases, that is 9 unanimous decisions, they split 14 to 1. I said that there were going to be. I said that there would be 16 left. That's 15. One was just too close to call. Excuse me. 12 to 1. The remaining 14, right? The conservatives won 9 out of 4. 1 no decision on my part. The 5-4 decisions are often the most revealing. There were 10 last term compared to 22 in the preceding term. Here, 5-4 decisions, it was split 5-5 between the conservatives and the liberals, which, after all, is quite good for a liberal minority. What's interesting about it is, of the 10, Justice Kennedy was a swing vote in 8 of them, particularly including the 6 biggest cases of the term. There were 2 other cases. One involved a flip-flop between Justice Breyer on the left and Justice Scalia on the right in a search and seizure case, in which Justice Scalia tends to be very favorably inclined, or more certainly than the other conservatives, in finding a violation of the Fourth Amendment. And the second one has to do with Chief Justice Roberts being joined by the 4 liberals. That is a very unusual situation in which he was the swing vote. It's usually not a swing vote. It's somewhat similar to the healthcare case a couple of years ago, in which he made 5 to uphold Obamacare. Okay, so that's where you have it in that way. As I said, Kennedy was the 6 of the 8 biggest cases. He was the key vote in 5 of them, Roberts being the other, which I may or may not get to, involving an abortion protest situation. Chief Justice Roberts' emerging importance is not, as I've indicated, in being a swing vote, but in leading the court to making very narrow decisions. And the consequences of that, it's a green light for more litigation. That's obvious. But I want to note that it quite possibly is going to end in some major liberal decisions being overturned by the court if, and this all assumes that the same 9 justices are going to stay on the Supreme Court. And there's no indication, at least in the subsequent 2 years, that there's going to be any change except by natural causes. Okay, let's take a look at some of the cases. The biggest case of the term, I think, carries a name that everybody recognizes, the Hobby Lobby case. It was clearly the most highly publicized of the term, but it is very important to note that it was not, and I'm going to underline the word not, a constitutional ruling. Rather, it was a statutory interpretation case called the Religious Freedom Restoration Act. The Religious Freedom Restoration Act was an act of Congress that overturned a Supreme Court decision, if you will, and sought to reinstate an earlier Supreme Court decision which was much more liberal in terms of protecting religious liberty. Okay. Then the court came back and said, oh, no, you don't do that. You don't tell us what the Constitution means. We tell you. And they said that that couldn't be done. They couldn't define the Due Process Clause. But they didn't have to do anything to do with limiting federal power. And this statute was interpreted to apply to all federal statutes, which made them subject to a very liberal, lenient, and strong protection of religious liberty. Okay, so what did the court do in the Hobby Lobby case? It held that RFRA, this Religious Freedom Restoration Act for religion, covers closely held for-profit corporations. It's important to understand that these were closely held for-profit corporations. Why? Nonprofits were already exempt from Obamacare by executive interpretation of it. This extended it, as I say, to closely held nonprofit corporations. And I think it's important to understand what this corporation was about. It was a very large corporation, but it was exclusively held by, I think, 4 or 5 members of the same family, several, all in the same lineage of that family. All right. And this group also only found that their religious beliefs were prohibited post-conception use of contraceptive devices. Only I'm not an expert on this, but it's a morning after pill is the biggest example of that. All right, that's the only thing. Didn't prevent, for example, condoms or consultation about birth control and so forth. Only it involved certain devices that would that would end conception after it has begun. Okay, and the consequence was that their religious belief was held to be protected by the Religious Freedom Restoration Act. The court split in its usual fashion, 5-4. Chief Justice Roberts didn't write, Justice Alito did, but notice Kennedy is with them on the winning side, and Justice Ginsburg, joined by the 3 liberals, dissented in a very strong dissent that sometimes comes back to bite you later on, in which they said, oh, the court decided all these things. Well, if they go decide it later, they'll say, look, even the Senate recognized that we decided this, that's the law. Okay, that's a very different situation. For me, this is one of the very narrow cases decided last term. Apart from the fact that it only applied to the federal government and not to the state, it left open the definition of what is a closely held corporation. And now, this was not simply a closely held corporation. This was a solely owned corporation, all by a single, up and down generational family of 4 or 5 people. I would say, I gotta be careful about that word predict, They said, as Yogi Berra once said, he said, predictions are very difficult, he said, especially when they involve the future. I would say that they are not going to hold. I think the California corporation law permits you to be a closely held corporation, 30 or 35 shareholders. If you have some real split on those, that's going to be a very different case. Very, very different than the lobby case. I want you to know one other thing interesting about this. This one involved, indirectly, a conflict between 2 constitutional rights, right? The statute protected the free exercise of religion, and what it did was it also permitted an exception to the right of women to have an abortion. So that comes up again as conflict between constitutional rights. The second case was not 5-4. Interestingly enough, it was unanimous. I think you all heard about this case too. It was the cell phone case. It was probably the second most highly publicized case of the term. It's clearly the least complicated. It's very, very simple. Any of you who practice criminal law know this better than I do, but the rest of you, all lawyers, you'll remember back in law school that a search conducted incident to a lawful arrest does not need a warrant. You can search someone that you've arrested lawfully in order to protect your arresting officer from weapons or to prevent the destruction of evidence. Was the big thing. Well, what happened is the police got a cell phone here. And they said it's a destruction of evidence because we want to look through that and we can find stuff that will link the defendant, the arrestee at least, to the crime. They said you have to go out and get a warrant absent exigent circumstances in which it's too much time to get a warrant. If, for example, they got, unfortunately, not an unreal case these days, a bunch of kids and they can say, in 20 minutes, that's the end of them or something like that, you can go in. Okay, look, most cases don't involve exigent circumstances. It was a unanimous decision by Chief Justice Roberts. The wags, said, well, it's because it's the only technology case in which the Supreme Court knew about because they all had cell phones. The interesting question about the case is, what happens when they do have probable cause, which they usually will, and there will not be any exigent circumstances. They don't have to, they have time to get a warrant. Today you can get a warrant, I'm told, pretty quickly, at least, in lots of jurisdictions. So they get a warrant, just like in the case that I gave you. There's probable cause, although that they wouldn't even need the warrant. But there's probable cause for it, and they get the cell phone. Now, this case doesn't talk about a situation like that. What happens then? The police then take and search the whole cell phone. That is going to involve almost a very high percentage of searches incident to a lawful arrest, because most of the criminals or the charged people, the defendants, are going to have cell phones too. So are they just going to be able to, go through the whole thing? And that's what you really have to do if you want to look for it. There's probable cause, no probable cause, but you want to stop the destruction of evidence. My prediction, I give another one again. Most people don't remember anyway. And I certainly don't remind them if I talk about the case the next time when it has been decided. I think it just follows naturally that they're going to say, no, you cannot simply, if you have probable cause, search the whole phone. I think you're going to have to give it to the judge and have some sort of in-camera inspection or something along those lines. So that's the cell phone case, and that's the remaining problem, it seems to me, with it. The third case I want to talk about is, I give these, the names by which they're most descriptive, the Affirmative Action case. It involved a state constitutional amendment in Michigan, which held, very much like our proposition, I think it was 209 in California, that race-based preferences in state university admissions should not be continued. And it was the same fellow who carried the spear for Proposition 209. I forget his name now, but what was his name?
Ward Churchill.
Huh?
Ward Churchill.
Yeah. Ward. He went and he did it in several states. I think Washington did it as well, state of Washington. Anyway, they passed this constitutional amendment. And the question was, does this constitutional amendment, which overturns the Affirmative Action program at the University of Michigan, is that a violation of the Equal Protection Clause of the 14th Amendment? And the court held that in this particular case, it does not violate the 14th Amendment. Why? Because it did not reflect any racial purpose. What was its purpose? They said the purpose was to simply, and I think this is a fair statement, to restore the status quo. After all, before this constitutional amendment, there was no affirmative action. Then the University of Michigan adopted a program for affirmative action. This one took it back to the original situation. That's what the majority reasoned. And this was the hook, or the difficult issue, that the rationale of several, which were really quite contrary Supreme Court decisions, and the court recognized that they were contrary. They said, well, there was dictum in those cases, and the rationale was both unnecessary, and the cases themselves raised, and I'm giving an exact quote, serious constitutional concerns. All right? The author of the court, as I said, was 6-2. Justice Kagan was out. She had been involved with the Department of Justice in other cases involving the same issue. It was 6-2. Justice Kennedy wrote for a plurality in the majority, joined only by Chief Justice Roberts and Justice Alito. All right? That's not unusual. For him to write the opinion, because he actually wrote a dissenting opinion in one of the cases that reached a different result. Although there are other reasons to believe that it might be somewhat different, but I don't want to go into that. In any event, as usual, he was on the winning side, and he was joined by Chief Justice Roberts and Justice Alito. Justices Scalia and Thomas did not join the opinion, but they concurred in the result. They simply said those prior cases were wrong, they should be overruled. He said, and only a racial purpose should violate the Equal Protection Clause. Interestingly, that only makes 5. I said it was 6-2. Justice Stephen Breyer, who is the one on the liberal side who is most likely to be pulled across the line, he concurred as well. And his position was that he thought that this question of disagreements over affirmative action should be resolved not by the courts, but by the citizens of the state, which is exactly what happened here. This was a constitutional amendment approved by the citizens of the state, as it was in California. I drop a footnote, I should say, that this was also tried to attack Proposition 209. It was overturned by a federal district judge in San Francisco, Henderson. Went up to the Ninth Circuit. They split pretty badly, but they overturned him, and the Supreme Court denied review. So it shows you the way things go on matters of this sort. Justices Sotomayor and Ginsburg dissented, and they said, this is not simply restoring the status quo. And what they really did is articulate the rationale of the prior cases which upheld programs of this sort. They said what this Michigan constitutional amendment does is to make it much more difficult to reinstate affirmative action for minority groups. Before, the decision-making group was simply the University of Michigan. All right, there, you just got to get to whatever it is, the Board of Regents, for example, here, or something like that. It's much more difficult to get often a plurality vote, a supermajority vote in a constitutional amendment, or in any event, a very expensive proposition, as many people know, in many states, to get a constitutional amendment passed. It made it more difficult. It wasn't simply a restoration of the status quo. Well, that's where it stands. I should say that I think the result that I read out of this case, if you're interested in the issue at all, is that it is going to be very, very difficult to get an affirmative action program sustained today, so long as the present court stays together. So long as it contains any kind of race as a specific criterion for being able to get admitted to the university. Okay. The union dues case is another one I want to talk about. This was another one that I'm going to say is important because what it promises rather than what it actually held. It was a 5-4 decision. It involved a rule of the court that's been around for a long time, 40 years, I would say, which involved public employee unions. And the rule was that if you're all familiar with public employee unions here, if you have a public employee union, then you can impose a fee on people who lost the election for the union. They don't belong to the union, but they can be required to pay a fee. It's called an agency fee to the union for the cost of the union's collective bargaining issues, but not for the union's political activities. One of these cases arose out of California, in which an organization called the Bar Association of the state of California, which supported abortion in the legislature in a strong way. And the court held that those who were opposed to that were entitled to part of their money back, that their dues could not be paid to support causes, political causes that they did not agree with, that was a violation of their First Amendment, freedom of speech and association. Okay? So what did the court do with this case? Well, the court held that the case, that it did not apply, all right, this rule, it did not apply to, quote, this is what their title was, personal assistance to home care recipients. Now, these were paid by the state, but they said they are not the traditional kind of state employee because they are almost wholly controlled by the recipients of the home care. Recipients don't like them, they get somebody else to come in and do it. And they did not have many of the benefits of run-of-the-mill state employees, such as differential pay, they didn't have that, or union help with any grievances. So they sort of said these so-called personal assistants were really independent contractors, and they couldn't be forced to pay any dues to the union because it violates their freedom of association. That is to say, to associate with a union that they didn't belong to, and that wasn't giving them all the benefits of what a state employee usually gets out of a union. Well, it was 5-4. It's the usual split. Justice Alito again wrote, plus the 4 conservatives, that includes Justice Kennedy, on the winning side, and Justice Kagan, joined by the other 3 liberals on the court, who are from, I guess, right to left. I would say Justice Breyer. I would then, these are not easy distinctions, but after Justice Breyer, I would say maybe Justice Sotomayor and Justice Kagan and Justice Ginsburg on the right. I think that the question between Sotomayor and Kagan is sometimes hard. I mean, it's hard to say, they'll split. You really didn't expect that very well. Okay, let me say this. I think this was a very limited case, right? It just didn't apply to a very, very small sliver of state employees. But it's a strong example of the conservatives being very narrow, even though Chief Justice Roberts didn't write the opinion. It may well be that they had to be this narrow to keep his vote, because I think he likes, and he said this in his confirmation hearings. He says, look, we don't make the law. We just do very little. We're just referees. We call 1 strike and 1 ball on every pitch. We don't automatically call someone out or what have you, except when you have to. In any event, it bodes, I think, more for the future. And again, I'll make a prediction. You get a case like this again, not involving an unusual kind of state employee, but a traditional kind of state employee, and this court stays together the way it is, they're going to overturn that old case and say you cannot force someone who doesn't belong to the union, doesn't want to belong to the union, to pay any dues at all. It'll be the union's problem to support what they are doing. Okay, I certainly can do 2 more cases, and there may be one left in the end that's too complicated to talk about. The third is a case that it's the same case come up many times. It's a case you all know the lead case, and that's Citizens United, which involves the question of campaign finance. And this case involved a federal statute, involved the same federal statute as in Citizens United, which makes a big dent into the decision does. It makes a big dent in the federal statute that seeks to restrict campaign, this one, contributions. Now it's true, it's been true from the beginning that the court had held back in the 1970s, just right in the post-Nixon era, that you could not, the government could not put limits on independent political expenditures, so long as the expenditures were not really expenditures by the candidate. Coordinated is what they say. Cannot be coordinated with the candidate. Got to make your expenditure and that's it. Although, you know perfectly well who you're supporting on this particular campaign contribution. But contributions were limited, and they've been limited ever since. And little by little, the court has been chipping away at these limits on campaign contribution as well, saying that they also violate the First Amendment freedom of speech, because money is speech when it is involved in a political process. It involved a statute that sought to limit the amount a person can contribute to all candidates. So you can contribute roughly $2,600 to one candidate. But you cannot contribute more than $50,000 to all political candidates in a given election. And I guess if you got enough of them, you know, you can go through to 2,600 pretty quickly and go over to 50,000. The court held campaign contributions are free speech. All right, that's really the first time they explicitly held that, and that Congress has many alternatives to prohibiting them altogether. They can regulate the contributions being shifted, you know, from one recipient to another. You know, you say, here's 5,000, but please give 2,400 to this other person who's running for office, a member of your same party. You get the point, right? But the biggest point is that it said that we have never held that Congress cannot require disclosure, full disclosure of all contributions. And full disclosure we don't have today. You don't know, you read these organizations, Committee for Freedom of something or other, right? Well, who's really behind that? Well, Congress can, anytime they want to do it, they can pass a law requiring that you give the real names of the people who are putting up the money on these contributions. And it was a very popular thought in Congress. The Republicans passed a bill that required all labor unions to report theirs, and the Democrats passed, they supported a bill saying, yeah, you can, no, not labor unions, it's corporations we want to make this sort of kind of disclosure. And as we know, at least today, never the twain is going to meet. But for those who don't like Citizens United, and there are lots of people who don't, they should be reminded that the court has said that there is a way to really make a big dent in this, and that is to require full disclosure of who you're really supporting. And it makes a big difference when you really know who the contributors are, instead of some fictitiously named committee. This was a 5-4 decision, the usual split. Chief Justice Roberts wrote for the 4 conservatives. Justice Kennedy was with him. Justice Breyer wrote for the 3 other liberal dissenters. I'll make another prediction. Sooner or later, if this court hangs together, it's going to get a case in which it says that we now hold that just like expenditures can't be limited at all, neither can contributions. It's in the card, because Congress has the same alternatives there too. And the big alternative is one that they refuse to do, and that is require full disclosure of all corporations and unions. Okay? All right. One more, and I will stop. The town meeting prayer case. These are all, I think, that many of you have read about. It was a 5-4 decision. It involved an opening prayer at a town meeting someplace in the country. And this town meeting, it's a fairly small town, and there was an opening prayer at these meetings, sometimes invoking Jesus Christ and similar phrases. It was open to clergy of all creeds, but like the community, it was predominantly Christian creeds, Christian representatives, leaders that were represented. The argument was this is a violation of the Establishment Clause to pray before a town meeting. The court held 5-4 that it did not violate the Establishment Clause. Why? Because there was no sectarian purpose to this, and historical practices and understanding show that this has been widely accepted, both by the framers, which is true, which permits the chaplains in Congress. That, interestingly enough, was passed by Congress the very same week that they proposed the Bill of Rights to the states. And the argument was, the opinion by Chief Justice Berger a bunch of years ago, they said, well, how could Congress have meant to prohibit in the very same week what they passed when they proposed the Bill of Rights? The Bill of Rights, apparently, in their thought, didn't prohibit this sort of thing. And then the court went on to say that it also is accepted by many faiths in the communities that are doing so not to convert anybody or proselytize, but to seek cooperation among people of all religions, even though they don't believe or agree on the same religious doctrine. It was a decision written by Justice Kennedy, a swing vote. He's in the middle of this. The other four conservative members of the court would go much beyond this sort in permitting religion in public places. The catchy phrase is religion in the public square. It goes all the way around, hanging 10 Commandments on the wall. It split them on the 10 Commandments cases. 10 Commandments posted in the Texas Capitol grounds. They upheld that was okay. And on the very same day, they said it was no good when in some Kentucky courthouses in a certain county posted the 10 Commandments on the wall. And again, one vote made the big difference in both of those cases. That was Justice Breyer. Anyway, Justice Kennedy would have upheld them all. So he wrote for the court. He was joined by Chief Justice Roberts and Alito. Interestingly, it was only for those three. The other two conservatives, Justices Thomas and Scalia, went much beyond that. I mean, pretty interesting. They don't have the votes for this close, but they said, no, the Establishment Clause doesn't apply to the states. That's it. It's only if, excuse me, it doesn't apply to federal government. It only stops the federal government from establishing a national church. And the question then is, well, what does the Establishment Clause, it becomes more technical, but it's not important. They believe, probably, that the Establishment Clause can't apply to the states. The states wouldn't have a national church. If it only means this, then that's all it means. And therefore, the states have much greater leeway with the federal government in having religious, even sectarian kinds of, that was a 10 Commandments case that split the court about 5 years ago. Justice Kagan and the three liberals dissented. Okay, I've got 1:15. We have 15 more minutes. Bob Neiman said, where are your criticisms, comments, or even questions? Yes, sir, in the back.
Comment on
Who's that, Ralph?
Any constitutional issues from yesterday from what the president said?
Oh, the immigration thing. Well, that is a it's going to be very, very close, all right? It's going to be a good test of something that I said earlier, and that is that the conservatives seek to uphold, or tend to uphold congressional power, executive power, whereas the Democrats more greatly favor the Congress on the court. Well, it's going to be interesting to see how they come out in that case. Because here you've got an executive that is Democratic Party, and you've got a Congress, both houses, controlled by the Republicans. That would be a real flip-flop for these members of the court. I think it's close. I mean, you have to take a look at all of the arguments. They have statutes, I'm sure, that say that partially authorize the president to do this sort of thing, and there's nothing new. About this issue. They've had cases filed, I think, but I'm not going anyplace, on the DREAM Act, in which he said kids of a certain age who are brought here, I forget, who are going to college and so forth, they would not be deported. And I don't know the answer to that. It's going to be close. There's no question about that. As well a case that they do have this term involving provisions of Obamacare, in which states that do not choose to have one of these markets, what do they call those? Exchanges, yes. Where you can, sort of bidding contest by the insurance companies. They all put up their policies and so forth, and they try to get people to sign up for those. And they finally got a split in the circuits, and they took the case, and I think it decided this term. Well, the big question is, well, is this just a replay of the Obamacare case of a couple of years ago? And the big question is, where will Chief Justice Roberts be on this one? And I want to make it clear, although people who are truly conservative think that Roberts, he's a traitor in many ways, or at least he was a bad appointment to the court. That Obamacare case, I didn't mean to talk about this today, but in answering the question, I want to say this. In that particular case, Chief Justice Roberts did hold that Obamacare was not unconstitutional, that it was within federal power. He relied on the taxing power. All right. I should say, in fairness, there were cases, but they haven't taken a look at these cases since the late 1930s. But there were cases which said, well, even if you don't have power under the Commerce Clause, you can have power under the Taxing Clause. But taxes were never challenged this way because there was virtually nothing for many, many years that you couldn't do under the Commerce Clause. So they always upheld they were regulatory taxes. They always upheld them under the Commerce Clause. Well, in the Obamacare case, he gave a relatively new, narrower definition of the scope of the Commerce Clause. People have overlooked that. That is just sitting there, and it seems to me it's a question of whether this is just the first step on his part to seek a narrower interpretation of the Commerce Clause so that the states can't that the Congress can't do anything that it wants under the Commerce Clause and violate states' rights. So it is a similar case. In that way. Now, you asked about separation of powers. I think this is going to be part of that, because what the president has done in the Obamacare case is the same thing. I mean, he's taken it. The argument is, look, it said that the state should have exchanges. It doesn't say that the federal government can have exchanges. And then the question will be, well, what does it say? What's the statutory interpretation? And to what extent is this within his constitutional power, even if it's not authorized by existing statutes? Somebody else? You all exhausted? Too much. Yes, sir.
Just the newspaper reported that the president's prerogative has been used by President Eisenhower, President Bush, President Reagan. Various presidents. Has it ever been challenged?
Well, there have been a lot of challenges to exercises of presidential power, but there have been very few resolved by the Supreme Court. Look, people, when they come from Congress to the presidency, as did President Obama, they change their stripes. Power begets power. And especially if you have one house of the legislature on your side. They all do that, right? Some of you, not enough, I guess, remember FDR. Oh my goodness. He really exercised power, executive power. Because it wasn't so much against the Congress, it was against the court. And he kept doing it and doing it and doing it. And finally he prevailed. He prevailed by changing the composition of the court. So I think it's going to be a very interesting question as to what's going to happen with this immigration matter. The president has been, Democrat or Republican, he's pretty flipped, he says, all I'm saying is that Congress should take this. I'll withdraw if they pass an immigration bill. In today's world, That's like saying that Cal can beat Stanford by about 40 points on Saturday. You know, all they got to do is make enough touchdowns, which they could, but it's a question of not having the other team score 45 points. Anybody else? One last chance before we are. Yes, sir.
Yeah, in California, Hobby Lobby, you had already exemption for, a nonprofit religious institution.
Yes.
In California, there's been some expansion of some of the California are requiring insurance. I'm wondering, where do you think it comes down where if there's not an exemption for a religious institution, for
The retreat. Look, the RFRA.
Yeah, RFRA for religious institutions and under the First Amendment in conflict with the abortion rights, right? That conflict between the two.
There it was. So I'm not quite sure what the question is.
I wonder where you think the court's going to come down on that one.
Oh, well, I think at a certain point, I think the court is going to say, look, it's one thing to have a closely held corporation that is wholly owned. It's another thing, as I said, to have a California corporation. It's got 30, 35 shareholders. It still qualifies under the Close Corporation Act in California, but it's got they're split all over the place. They got Catholics, they got Jews, they got Protestants, they have Muslims, and so forth. California, they have Buddhists, and some of them are opposed, some of them aren't opposed. Depends on what the particular regulation is. I think the court is going to say, no, we're going to give the Religious Freedom Restoration Act a broad meaning, because the court got in a certain amount. Look, that statute, this was a case. We used to have this rule before. I just said the constitutional rule back in the middle 1960s was that if you have a neutral regulation, all right, which happens to pinch a particular religion. We know all, there are so many examples of that sort of thing. For example, the Compulsory Education Act, right? That you got to send your kid, let's say, to high school until he or she is at least 16 years old. And the court held, well, that's a neutral regulation, didn't have anything to do with religion. But the Mormon Church had a different view of it. They wanted to take their kids at a certain age below the statutory requirement, which every single one has. They felt they got to come back on a farm and learn what the religion is all about, and they won't be corrupted by more public schooling. And the court, with only one dissent, held that the Constitution requires an exemption for the Mormons. A very, very famous case back in the early 1970s, written by Chief Justice Berkeley. So I say it was 8-1. Well, the court overturned that case in 1990, involving the question of the use of peyote. And peyote is what they call a Class 1 drug in the federal system. And it's hallucinatory, there's no question about that. They held that, but the Native American religion requires the use of peyote at their ceremonies. This was not, some ancillary little practice to religion. This was central to their religion, on their ceremonies, the Native American church. And the court held, no, it's a neutral rule, overturning. They didn't say they were overturning it, but they were. And saying a neutral rule, the First Amendment doesn't apply. First Amendment only applies when you single out religion for adverse treatment. There are cases like that. But this one, but the normal rule, and they pointed out, we have so many religions in this country. A decision written by Justice Scalia, you see, interestingly enough, which was very narrow on the free exercise clause. And he didn't want the court balancing every regulation as against the religion. He said, yeah, if it's neutral, that's the end of it. Well, I think there's a growing number of people on the court since 1990 who didn't like that decision, didn't like the decision. And the bottom line is that I think they may overturn that one of these days, although they won't get his vote. It won't be easy to do that, but I think they're probably enough to overturn that decision. So I forget what the question was, but that's the sort of issue you can face. Okay. Thank you all for your attention.